provisions in franchise agreements. Raja Patil and his partner Michael McGee. Raja is a partner in the Dentons, Greenbaum law firm out of Louisville, Kentucky. He's the national co-chair of Dentons Franchising and Distribution Group. As you can see from his bio, he's closed hundreds of transactions involving franchise businesses, including hotels. He's received the Best Lawyers recognition in the areas of real estate law and banking and finance law from 2018 to today. Ladies and gentlemen, please welcome Raja. Joining him will be his partner Michael McGee, also a partner in Dentons' office in Louisville, Kentucky. Frequently represents clients in the hospitality industry as well as other franchise businesses, and he's received not only Best Lawyers Ones to Watch, but also Super Lawyers recognition 2021 to this year also. Please welcome Michael. Take it away, gentlemen.
All right, thank you, Stephen. And although I have these recognitions, I don't know if I can work this microphone.
Can I take that one, maybe? Yeah, that just, did you hit the on button?
Yeah?
That helps.
Yeah? Okay.
There you go, sorry.
Voila.
I had to learn the hard way too.
Thanks for that introduction. I think next year we have a giant piece of paper that we come busting through just to add dramatic effect, but I appreciate the kind words there. I'm Raj Patil, that's Michael McGee, in case you're wondering. And don't let your eyes deceive you. It is Patil, not Patel. Just by show of hands, how many of you know a Patel? Specifically in the hotel industry. And how many of you know a Patil other than me? So, get mistaken a lot, but they're different. So Michael and I, as Stephen said, are transactional attorneys. We do a lot on the franchisor and franchisee side. On the franchisor side, we've actually started some franchises with restaurants and support them in their franchisor side activities. We also do a lot on the franchisee side. I'd say the majority of what we do is actually on the franchisee side, and that'll be really the focus of this presentation today. I mean, as we all know, franchise agreements are very long, complicated documents, really too long and complicated in my opinion, but they really govern the entire relationship between franchisor and franchisee, and they touch on things like IP rights and licensing, franchise fees and royalties, advertising and marketing fees, development and operational standards, expiration and termination provisions as well. It's much of the time it's the manner in which they're presented that makes franchisees feel like they're not negotiable. If you talk to an average hotel franchisee, they'll say it's non-negotiable. Some of my clients don't even review the franchise agreements. They just sign it on DocuSign, which I think is a horrible idea. At the very least, you need to understand what's in there. So a lot of times we'll go through and summarize the provisions, the applicable provisions. But I still believe even in those cases, there is some ability to negotiate key provisions, and we'll be discussing some of those today. As noted in the slides, I think if you want to go to the next slide. Franchisees with prior experience with a particular flag may have more marketing power, and franchisees with newer brands might be able to get more concessions because these franchisors are just trying to get some more franchisees in the door. And although we could really spend the rest of the day talking through the guts of a franchise agreement, and there's a lot in the typical one, we're really going to be focusing on those key negotiable points that you can negotiate to help protect the franchisee, its owners, the management company if there is one, from really undue legal and financial risks. So without further ado, I'll turn over to my esteemed colleague, Michael.
Yeah, so the first provision or type of provision we wanted to flag, I think this is probably one of the most important ones. In fact, we spoke with one of our clients yesterday who has, 30 or 40 franchise hotels. And we were just wanting to pick his brain as to what he saw as sort of a common negotiable provision that's important to him as a business operator, that this is the first thing he said. So we're specifically talking about areas of protection or geographic restriction in favor of the franchisee. So when I think of a franchise relationship, I think of a franchisee getting sort of a turnkey operation from the franchisor. Franchisor has an established platform, a well-established brand with associated goodwill, and franchisees relying on that when entering into the relationship. So I think kind of implicit in that is that the franchisee will be free from interference by the franchisor and other franchisees within the system in the course of operating its business. So, one way interference can occur is if the franchisor grants franchise rights to another franchisee within close proximity to our client. And the concern there obviously is that may cannibalize sales, impact the franchisee's bottom line. It may very well cause the franchisee to trip up over financial covenants and loan documents, lease agreements, the franchise agreement itself perhaps. So it's really important to focus on that restricted territory concept in the franchise agreement for that reason. This is a very fact-dependent inquiry. The exact scope and the exact radius of the protected territory is going to be dependent on a host of factors. Primarily, that's going to be whether we're kind of in a rural area, or more of an urban market. So if we're in a rural area, the restricted territory may be a lot broader just because there's not as much demand. Whereas in an urban market, like here in DC or New York or other big cities, that restricted territory may be quite narrow, maybe less than a mile. So it is very fact dependent. There can be studies performed that will show the impact of a competitor opening within a specific space that they can sort of aid in determining the appropriate territory. So it is very fact dependent, but nonetheless important. Another thing that we try to do with franchisors who have multiple flags, if it's a hotel, or franchisors with multiple brands, in addition to restricting the franchisor from granting franchises for that same brand or that same flag within the restricted territory, we also sometimes like to try to restrict the franchisor from granting franchises for brands or flags that could be competing even though it's not the same brand. So for instance, like in the hotel context, you may use the STR chain scales, and restrict the franchisor from granting a franchise for a chain sort of on that same level of the chain scales in the restricted territory. And there's multiple other ways to do that, but if we can, we like to try to make this concept as broad as possible. The next, and there's a whole lot I'll go through on this next issue, but just generally speaking, term renewal and termination, we're just talking about sort of the duration, the life cycle of the relationship. So just at the outset, thinking of, every franchise agreement is going to have an initial term and probably will have renewal terms. There's two ways to look at it, and that's kind of going to be dependent on the franchisee, the state of the market, again, a whole host of factors that can go into that. But just to give an example, we've worked with more inexperienced franchisees before where this may be their first foray into operating a hotel. In that instance, we often advise the franchisee that they may want to negotiate a shorter initial term with maybe more renewal terms on the back end, with the thinking being a shorter initial term sort of helps insulate them from financial and other legal risk in the hopefully unlikely event that things go south and the agreement has to be terminated early. Conversely, a more experienced franchisee, like the client we were speaking with yesterday, where they have experience, they prove their worth, they know how to operate a hotel successfully, they may want to negotiate a longer initial term, just to give certainty as to the duration of their business relationship with the franchisor. So again, another sort of fact or circumstance dependent issue is something we always like to focus on and make sure that we get right for each client depending on their circumstances. Another thing we like to make sure that we understand and that is clear, because we've seen people get tripped up on this. Renewal provisions. So those can be tricky. Sometimes an agreement will automatically renew unless a party provides notice that it doesn't want for the agreement to renew. Sometimes express notice of renewal is required. So it's important, that's not something necessarily that you would negotiate with the franchisor, just something I wanted to mention on this particular topic, that we like to be clear with our clients about, so they know what the expectation is and don't get tripped up when the agreement is up for renewal. Another thing that we've come across from time to time, like in any commercial agreement, a franchise agreement is going to have default and remedy provisions in favor of the franchisor if there's a default by the franchisee. At times we've seen pretty aggressive or even no cure periods for franchisee defaults. And so where we come across those, we always like to provide for cure rights if they're not cure rights. And reasonable cure periods in favor of the franchisee, again, if those are not in the agreement. I think if there is a default by the franchisee, I think it's perfectly fair for the franchisee, except maybe in certain circumstances, like where there's criminal conduct or fraud or something like that. But by and large, I think the expectation should be that the franchisee has the ability to cure any default. Another related topic here is liquidated damages. So, a lot of you probably know, pretty frequently in a franchise agreement, the agreement will provide for liquidated damages in favor of the franchisor if the agreement is terminated prior to its slated expiration date due to a franchisee default. So that is very common. It's something we typically tell our clients that they'll need to sort of grin and bear it. But it is important, in order for liquidated damages provisions to be enforceable in the first place, it's important that they be objectively ascertainable. Hopefully there's some sort of formula or even a flat monetary amount that's set forth in the franchise agreement that just makes it crystal clear as to what is owed. And then also it needs to actually and fairly represent potential damages that the franchisor may incur due to a franchisee default. So, for example, a liquidated damages provision that requires the franchisee to pay the franchisor 5 years worth of royalties upon an early termination, probably not enforceable, because I doubt that kind of fairly or reasonably represents damages of the franchisor in that instance. The thinking being that a franchisor should be able to find a substitute operator, substitute franchisee well within that 5-year window. So, it's important to be on the lookout for those types of unfair sort of calculations of liquidated damages.
Yeah, and on that, this is an area where we have had success in reducing the number of years of sort of royalties that are embedded sort of in calculation of liquidated damages. So, this is definitely something that, in our experience, is negotiable. I'll also sort of distinguish the liquidated damages provision from an early termination right. So that's really exercisable within the franchisee's discretion. Within a certain number of years, upon a payment of a certain sum, might give you a right to terminate early, even if it's especially if the operations are not going sort of as planned. There's also other ways that sometimes that are other provisions you can put in these franchise agreements to allow you some way to get out of a franchise agreement for circumstances beyond your control. What I'm working with right now is where if the lease that the operating business is operating from is not renewed, so it expires and there's nowhere to operate the franchise business from, the franchise agreement will terminate. So it's important to keep those things in mind that are really outside of the operator / franchisee's control.
The last point, I'm not sure we even have this on the slides, but we wanted to raise it. A lot of times, or somewhat often, a franchisor will offer funds to the franchisee at the front end of the relationship for development or assistance with other costs.
Usually key money in hotels.
Yeah. So we've seen that come back and bite clients from time to time, in the event of an early termination where they get hit with a huge bill for that full amount. So I think just the lesson or the takeaway here is that if there are any advanced amounts under the franchise agreement, it just needs to be crystal clear as to how those are, usually they're amortized over the term, or somehow paid back. So just important to be aware of that and make sure that that's clearly handled in the agreement. Last thing on this slide we wanted to talk about are personal guarantees or parent guarantees as well. We see those from time to time. So fairly often, especially with more inexperienced franchisees, we'll see the franchisor require a personal guarantee from the owners of the franchisee entity. As a business, as a corporate transactional attorney, pretty much always, we'll set up a limited liability entity like an LLC or a limited partnership or corporation to serve as the franchisee entity. And the whole reason to do that is to insulate its owners from liability. So for that reason, we like to try to negotiate limitations under any personal or parent guarantees. And there's lots of different ways you can do that. I think the most frequent are what is called a burn-off. So the guarantee either expires after a certain amount of time, or maybe there's an aggregate cap that steps down over time. We see that quite frequently. As I just mentioned, a lot of times we'll try to impose a monetary cap on liabilities. So for instance, we may try to limit the owner's liability to 1 year's worth of royalties, for instance. We've seen that quite a bit. Another limitation we see from time to time is just limiting the enforceability of the guarantee against the owner to just certain bad acts, like gross negligence, fraud, criminal conduct. This is sometimes called a bad guarantee. Some of you know that term. So like I said, there's a lot of different ways we can impose limitations on a guarantee, but I would say those are the most frequent.
And I guess a related issue, this isn't exactly a personal guarantee or a parent guarantee issue, but you got to keep an eye on cross-default provisions in these franchise agreements. For Michael was saying, we set up these individual entities to limit the liability to, the capital contributions to that entity. But the franchise agreement has a cross-default, and all the other franchise agreements for all the affiliated entities, it could be a disaster if one goes into default. It shouldn't take down the whole house of cards, so to speak.
Okay, next point, we'll go through these next 2 points pretty quickly, really. But it's important, I think, to discuss. So, a lot of times a franchise agreement will impose limitations on the franchisee's ability to hire an outside manager or third-party manager to operate the hotel. Some of our clients have robust operations where they do have people that can to manage and operate individual investors who have no operational wherewithal to manage the hotel themselves, so they have to hire a third-party manager. So just important to understand, depending on your client's needs or circumstances, whether there are any restrictions or approval rights in favor of the franchisor as to the management of the hotel. Another thing that came up, and I'm not sure, this may be going away a little bit as the impact of COVID hopefully continues to wane. But I think we have heard about some franchisors offering reduced royalty fees if you use the franchisor's affiliated management entity. Again, that's not every franchisor. I think that is probably becoming a little less common, but that is something we've seen.
And I think Marriott does that. It's fairly common standard fees as the management company. So different flags treated differently.
And then the other point here, in a hotel context and a restaurant context, typically the franchisor is going to have a list of approved suppliers, where the business will purchase food and beverage, linen, and all that good stuff that goes into the operation of a hotel or restaurant. So that's all very common. That's completely expected. What we do like to try to make sure is included is, to the extent that the franchisor does have the benefit of any volume discounts or rebates from those suppliers, that they're passed along to the franchisee somehow. So that's an important item we'd like to be on.
Yeah, that's a big issue right now. And for those of you that follow, AHO, Asian American Hotel Owner Association, this is a really big issue in New Jersey right now. There's actually wrote it down. It's the New Jersey Franchise Practices Act. It's a bill that's been introduced, hasn't been passed yet. But one of the elements of that bill is basically that there's greater transparency on franchisor rebates, commissions, and kickbacks. And then again, as Michael was saying, those go to the franchisees, not the franchisor. So that's part of the bill. I think you're going to see a lot more push for that greater transparency on those rebates.
Yeah. So the last point on this slide deals with transfer of ownership. So, pretty frequently we have clients that own a hotel for a number of years and then decide that it's time to exit. And usually when that occurs, the franchise agreement will be assigned to the new operator. So I think that the takeaway here is that we like to negotiate concepts in the assignment provisions that hopefully allow the franchisee to assign to a buyer without undue burden or cost. And so one of the ways we frequently like to do that is we'll include language that says that the franchisor can unreasonably withhold its consent to the assignment if we're assigning to someone who is already an established operator under that brand, or who has otherwise been approved by the brand to operate hotels or restaurants under that flag or that brand. So that's probably the most common way that we try to do that is in this context. We'll also try to be on the lookout for transfer fees that are sought in connection with the assignment. We've seen some pretty exorbitant fees sought from time to time. Ultimately it's a business call for the client as to whether they want to accept that fee. But we do like to chime in when we see an exorbitant franchise fee or transfer fee, that's contained within the franchise agreement. Another big thing we've seen hold up deals quite frequently is maintenance and repair obligations. So we've seen deals get held up before with the franchisor as part of its approval process requiring either the current franchisee or the assignee to undertake renovations or upgrades to the hotel or the restaurant that are not necessarily contemplated under the current brand standards. can be quite costly. We've seen pretty large amounts tied to those upgrades being sought by the franchisor. So we always like to be clear that the consent by the franchisor to an assignment of the franchise agreement can't be held up for as long as the franchisee is currently in compliance with any current brand standards, upgrades, etc.
And it's important in the transfer document, it's clear who takes on those property improvement plan fee, PIP, as we call it in the hotel industry. So it's, a lot of times people don't put that in the asset purchase agreement or purchase and sale agreement, and it's a big mystery who's gonna be responsible for this fee, so it's really important.
Yeah.
I think that concludes our presentation. I won't hold you guys away from lunch for too long, but we can take questions if you want, Stephen, or around over lunch. And all that.
Yeah, we've got just a minute or two.
Somebody has a question? Yeah? We've got one. Juliet, please go ahead. Okay, one second. Okay.
Thank you. I had a question about misconduct allegations. I find there's always kind of a disconnect between the franchise owners and the franchisor, or who's responsible. And I know legally there are certainly cases about it, but when the franchise owners don't address misconduct, the reputation that's damaged is the franchisor. So I never see in the agreements that if you have harassment, you have bribery, fraud, whatever, who you have to take care of, or the franchise understand at times that they do have insurance, you don't have legal compliance. So I don't have the team that
Raj, can you kind of just summarize the question for everybody?
I think you're talking about the allocation of responsibility for different types of claims for franchisor versus franchisee, and I think there's lots of different buckets here. I mean, we all heard of joint employer doctrine issues where franchisor are pulled into lawsuits involving franchisee employees. Really a well-written franchise agreement. I'm going over the franchisor side on this side. I mean, usually these cases are tied to the degree of control that the franchisor exerts over the employees. And Jordan and others can tell you a lot more about that. But, a well-written franchise agreement should really say you're in control of your employees, and any employment claims or responsibility for any of those types of claims should rest with the franchisee. But I was thinking during Jordan's presentation about these ADA website claims. A lot of times the franchisors are the ones that are putting the websites together. So you don't really see that addressed who the responsible party is if they miss something in that website that results in an ADA claim. I don't remember ever seeing much of that or the allocation of responsibility. I almost feel like some of those claims should go to the franchisor if they're the ones putting it together. So it depends on the type of claim, I guess is the way I would say.
Yeah, I think that likely that could be settled, but still no changes to the agreement, right? That really spell out that you have to do this.
I think that usually indemnification provisions in franchise agreements would typically allocate at least employee responsibility to franchisees. I think I'm pretty familiar with seeing those. Yeah.
Question over here.
So how receptive are the brands to making these adjustments? And so fair enough, I actually worked for one of those brands for 8 years, and now I'm back on the property side, so I'm just a little curious on how receptive they are in that conversation.
Depends.
On the one hand,
If we're talking about restaurants, I think it really depends on the restaurant and the size of the restaurant franchise. But talking about hotels, again, I think there's a perception in the market that they're not very negotiable. But it does depend on how large of a franchisee is in that particular flag or brand. It depends on whether it's a newer brand. You might have more bargaining power. So, but in general, I think the topics that we covered today, I believe all of them are largely negotiable. I mean, we have had success on a number of fronts on everything we discussed today in the hotel context.
Yeah, I would say in a normal, not normal, in a circumstance where you're dealing with an established larger brand, I would say we would typically only comment on these items, and we probably won't win all of them, maybe win, I don't know, 3 or 4. But, you know, as Raja mentioned, having negotiated a couple franchise agreements in the past year with newer brands where I'm representing literally the first franchisees, and those agreements were heavily negotiated. We got quite a few changes to those, so it really is dependent, I think, on the fact dependent, just on the nature of the brand.
And this is probably more relevant in the restaurant context. I meant to mention this earlier in the geographic restrictions section. But, you know, a lot of times you'll have these multi-unit development agreements where, you know, I'll be the exclusive, I don't know, Chick-fil-A franchisee for the state of insert the blank. And, you know, in those documents, it's usually like, we are going to open 5 new stores within the next 5 years. And as a result, you're going to waive your franchise fees up front. You're going to reduce your royalties, you know. So some of those things can also be addressed in the multi-unit development agreement. So it's also important you know when you're analyzing these types of claims or disputes or negotiations, that you see the bigger picture and have all of those documents in front of you.
Let's say thank you very much, Raj and Michael. Thanks, gentlemen.